the court have had a busy day, some have had a busier day than others. What I've done is put into a note in bullet point form our responses to some of the arguments that Mr. Allen made, and I'll come to that note in due course, but the aim is to shorten my submissions. What I want to do, if I may, is focus on the four authorities, Schnorbus, Bressol, Pat Malnice and Preddy, which we submit Mr. Allen has to persuade you are wrong in the result in the case of Bressol and Pat Malnice, because as you appreciate, they're nationality cases, and wrong in the reasoning in the case of all four. Maybe I'll take them briefly because I know that the court's familiar with those authorities. The first is Schnorbus. I won't even ask the court to turn that up at this stage because the material aspects of the Schnorbus case are covered in the other three authorities that I'm going to look at. The court will know, of course, that Schnorbus was the case which concerned the question of immediate or deferred legal training according to whether the potential candidates satisfied a broad criterion of particular hardship. One of the bases on which they could show that they had experienced particular hardship was that they had undergone national service. National service was, of course, compulsory for men, but not open to women. And the question arose, is that direct discrimination or is it indirect discrimination? And the European Court said it was indirect discrimination. That's it on Schnorbus for the time being. Can I turn nextly to Bressol? In relation to that, I do wish to show you, if I may, or remind you at least, of certain short passages in Bressol. So I can ask you to take up volume 5. Bressol's behind tab 56.
Page?
It starts at 1945, but I'm going to go, if I may, to 1963, which is in the opinion of Advocate General Sharpston. Before I deal with the passages that I wanted to remind you of, can I just remind you of the factual pattern, which, as the Supreme Court observed, as identical to the fact pattern in Pat Malnice. In Bressol, as you will know, the question was access to free higher education in Belgium. There were more places in higher education for residents, as defined, than for non-residents. In order to be classified as a resident for these purposes, you had to have your principal place of residence in Belgium. But you also had to be able to satisfy one of 8 additional conditions. One of those 8 conditions was that you had a right to remain in Belgium, a right to reside in Belgium, a permanent right. That was a condition which all Belgian nationals could satisfy because they had it as a result of their nationality. But it was a condition which only some non-Belgians could satisfy. Non-Belgians needed to be resident for 5 years before they acquired a right to permanent residence. And so you had a 100% pass rate on the part of Belgians, but a less than 100% pass rate on the part of non-Belgians. And again, the question was whether that was direct discrimination, direct nationality discrimination, or indirect nationality discrimination. And you know that the court held indirect nationality discrimination. And I made the point that Mr. Allen needs to persuade you that Bressol was wrong in the result, because on his analysis, in my submission at least, this would obviously be direct nationality discrimination, because of whichever formulation one cares to choose from the numerous formulations he advanced. Now, that, in a sense, is sufficient for present purposes, so I'll be brief, but if you have page 1963, you've got there at paragraph 52 the definition proposed by Advocate General Jacobs in the Schnorbus case, from which the test of being necessarily linked to a characteristic indissociable from sex originated, I think. You can see it's in italics. Advocate General Sharpston then discusses the case law up to paragraph 56 and proposes her own test. And you can see at the end of line 3 in paragraph 56, I take there to be direct discrimination when the category of those receiving a certain advantage and the category of those suffering a correlative disadvantage coincide exactly with the respective categories of persons, distinguished only by applying a prohibited classification. So one might call that the exact coincidence test. With great respect to Advocate General Sharpston, the oddity was that having proposed an exact coincidence test, she then proposed that the right to reside criterion should be regarded as directly discriminatory. And one sees that in paragraphs 64 to 67. And in particular, paragraph 67, the difference in treatment is clearly based on a criterion, the right to remain permanently in Belgium, which is necessarily linked to a characteristic indissociable from nationality, and therefore it's direct discrimination. And as we'll see in a moment, Lady Hale remarked on that. She didn't put it as rudely as I did, obviously, but she remarked on the fact that the test advanced didn't actually suggest the answer given. We also know, or the court knows, that the European Court of Justice then proceeded, if you've got 1991, page 1991, paragraph 62, on the basis that this was indirect discrimination. And as I pointed out on Mr. Allen's case, they should have said direct discrimination. Lady, I'm not sure there's, in the context of the present case, there's a great deal more one needs to say about the Bressel case, or as to how Advocate General Sharpston came to propose the answer when applying the test that she proposed. But as it were, as a footnote, one notes that she placed significant emphasis on the pregnancy cases in her reasoning. And there is discussion of that by Advocate General Jacobs along the lines that, well, this is a inherent biological criterion. Insofar as it's relevant, and I'm simply say it's a footnote point, the pregnancy cases really don't assist in relation to this particular analysis. Not because, with respect to Advocate General Jacobs, it's to do with whether it's a biological criterion or a statutory criterion, but essentially because the pregnancy cases are driven by particular community law policy considerations. And the court will know that arising from this jurisdiction, Webb and EMO, there were arguments put that you should compare the position of a pregnant employee with that of a sick man, or a man who has an analogous condition. And essentially, I would submit the European case law is, in answer to that, is saying there is no analogy with pregnancy, and for social policy reasons, pregnancy discrimination should be direct discrimination. And it may be that that is a better explanation than the one given by Advocate General Jacobs to the pregnancy cases, and it may be why, as it were, error crept in Advocate General Sharpston's analysis, because it was heavily based on a comparison with the pregnancy cases. That's all I was going to say on Bressel, unless there was anything else you'd wish me to address.
I think not.
Can I go then to Pat Malney's? That's in volume 4. at tab 40, it starts at page 1487. I only have a few brief points to make about the case. The first is obviously that the fact pattern was essentially the same as in Bressel. That you had there a right to reside criterion being applied to determine the outcome of a habitual residence test. UK nationals, in broad terms, had a right to reside, but not all non-UK nationals did not have a right to reside. The second point, therefore, is that this is the second case which I submitted that Mr. Allen has to say was wrong in the result, because his case is that this is direct nationality discrimination. The third point that I wanted to make is in relation to this question whether these types of cases should be regarded as cases where there are cumulative criteria and the offending criterion subsumed within the criteria as a whole, which appeared to be part of Mr. Allen's submission. And I immediately accept that that is the way that Lord Hope approached the problem. It appears, if I can put it in perhaps over-familiar terms, that Bressel caused a certain amount of head-scratching on the part of the members of the Supreme Court as to why the answer was indirect discrimination. And Lord Hope proposed that even though he considered that the right to reside criterion was direct discrimination, because it was subsumed in the cumulative criteria as a whole, the European Court had taken the view that it was indirect. Now, I've submitted, obviously, when I looked at the facts of our case, that there is an analogy to be drawn, that there are various factors in play in the present case, in addition to the immigration status factor. So there's an analogy to be drawn, but I'm not proposing that that is the right way to deal with this type of case. Can I illustrate why in more stark terms? That it would be no answer to say, well, our criteria are that you must be white and habitually resident in the United Kingdom, because obviously that would exclude all people who were not white and would amount to direct discrimination. And I entirely accept that it would be quite wrong to say, well, no, it's an indirect discrimination case, because there's more than one criterion, and they might have been excluded anyway, for example. So I would respectfully differ, or invite you to differ from Lord Hope insofar as you need to, as to whether looking at it in terms of cumulative or single criteria is the right way to analyse the situation. The question in my submission is always whether the criterion, which was the reason or part of the reason for the decision, is itself nationality. And that's, as I've submitted, that's what this case is about. Now, if one then goes into the judgment of Lord Walker at page 1510, what I've just...
I have a certain problem with this whole argument, because these cases are all about the tricky question of direct and indirect discrimination. Yes. This case is really about whether treating somebody badly for the reasons found by the employment tribunals amounts to discrimination of any sort on grounds of nationality or citizenship.
Yes.
And that's really what the issue is.
Yes.
And so although these cases are extremely interesting because they combine a prohibited characteristic with other features, I'm not quite sure how much help they give us in answering this case, but
Well,
maybe they do.
My submission, obviously, is that they do.
Well, they help you, yes.
No,
Maybe they don't help either of you, is what I'm getting at.
Well, I totally accept the point, obviously, that the central debate in these cases was the delineation between direct and indirect discrimination. But I do submit that in the course of analysing the basis on which such cases should be delineated, a clear test was derived as to what would amount to direct discrimination. And that test, of course, was derived in the context of there being various reasons for the treatment in question. And as I pointed out, I appreciate it's a rather broad submission, but as I've pointed out on Mr. Allen's analysis, Pat Malnice was a case of direct discrimination, as was Bressol. So all I wanted to say about Lord Walker's judgment was that I respectfully adopt what he said at 63G in expressing concern about the notion that because there are cumulative factors, the mere fact that one of them is directly discriminatory may not matter. Then if we may go into Lady Hale's judgment at 1518, again, I don't propose to read it all back to you, but you can see that, as I would submit, supporting the case on this side of the court, a consistent or a test is being developed through the case law. We can see reference to Schnorbus, Advocate General Jacobs. We can see at paragraph 90, the James and Eastleigh case being referred to. I respectfully adopt the points made by Baroness Hale about whether it's sufficient to explain the pregnancy cases on the basis of physical characteristics as opposed to statutory ones. Then at paragraph 91, one can see the exact coincidence test being referred to, and then, as I indicated when we were looking at Bressol, my lady, in my respectful submission, rightly points out that whilst the test of exact coincidence may well be the right test, Advocate General Sharpton's application of it was incorrect with respect to, but she went on to opine that this test was fulfilled where there was no exact congruence between those advantaged and those disadvantaged by the requirement in question. Thus, she held that it was direct discrimination on grounds of nationality, when both Belgians and other nationals might fulfil the requirement of a right to remain permanently in Belgium, but only Belgians could do so automatically. This may be an attractive approach, but it's of course the exact equivalent to the situation in this case. It's certainly a development of the principle established in Schnorbus. It suggests that there can be direct discrimination even when some members of the disadvantaged group do fulfil the requirement in question, even though others do not. The equivalent in the Schnorbus case would have been if all men were eligible to national service, but only some women were eligible to do so. And then the observation that at all events it's clear that the court didn't agree with the Advocate General's answer. That's all I propose to take from Pat Malnice. May we go then to Preddy at tab 45. The court knows the facts in Preddy. I've already pointed out that obviously they're not facts which relate to statutory criteria or the government dealing with its citizens or even public institutions dealing with citizens. He referred to personal interchange, and this is very much a case involving a personal interchange between the defendants who ran the B&B and the claimants.
Yes, it was, but it was still a criterion.
Yes, exactly.
They had a criterion.
I agree. I'm submitting it doesn't make any difference to the analysis. So, as to the points that I take from Preddy, well, essentially, I adopt the analysis at paragraph 18 and following on page 1612 in Baroness Hale's judgment, again, one can see the line of case law being traced. And one can see what I've submitted is a very practical formulation of the tests identified in that case law. For exact correspondence, I've submitted is a practical and clear test, whereas, for example, indissociable link is the same thing but less clear. And what one could see without my needing to read you back paragraphs 18 to 24 is that the starting point of the analysis in Preddy was that if one simply applied the exact correspondence test, or simply applied the exact correspondence test, one would get the answer that this was not direct discrimination because there were heterosexual unmarried couples who would not qualify under the criterion being applied by the owners of the B&B. And one can pick it up, for example, at paragraph 23 on page 1613. There is not an exact correspondence between the disadvantage and the protected characteristic. In Black and Wilkinson, Lord Dyson confessed to some difficulty in agreeing with the view that the James case compels the conclusion that there's direct discrimination in Preddy. In his view, this is not a case of direct discrimination against a homosexual couple on the ground of their sexual orientation, since there were other unmarried couples who would also be denied accommodation on the ground that they too were unmarried. And then this case solely about discrimination against the unmarried, I would agree with him. So ultimately, as I submit, the court was saying this is the test, exact correspondence. Yes, it would not be direct discrimination if unmarried heterosexual couples were part of the comparator group. And my lady Baroness Hale's judgment then went on to say, but in effect to say, but they are not part of the comparator group because civil partnership is, as a matter of law, the material comparable circumstance, and you've got to compare civil partners with married couples, and what's the difference between the two? Sexual orientation. Hence, it was direct discrimination.
The basic problem, Mr. Linden, in all these cases,
yes,
really, is how to draw the comparator, how widely to draw the circle of comparison. This case has been argued, certainly in the Court of Appeal, on the basis that the comparison is between non-British and British. If that is the comparison, then, speaking for myself, it's clear there is no congruence there.
Yes.
But Mr. Allen is nothing if not agile. And you'll remember the moment when he interrupted you, with the court's permission yesterday, to say that the comparator was somebody lawfully here, not subject to a domestic worker visa. Well, if that's the comparator, there's an argument for saying there is an exact congruence. So you pays your money and you takes your choice, Mr. Linden.
Well, I'm not at the moment seeing how that does make a difference to the analysis. The criterion that we're concerned with in this case is vulnerable immigration status.
Quite. And
Does it?
He picks that through and says that the basic nationality problem, the basic immigration problem, the basic status problem all emanates from the domestic worker visa. And so that's his line to say this is nationality. But he's drawn the comparison when he got to his feet very, very narrowly. Is that permissible?
Well, in my submission, no, because you have to work on the basis that this is a criterion being applied which disadvantages people of a particular nationality, I accept, but doesn't disadvantage all people who are not British. That's essentially my argument.
Yes.
It's not a 100% on pass and fail rate is ultimately my answer.
My lord is obviously correct in saying, drawn in that way, you could have 100% pass and fail rate. But the question still remains, is the characteristic thus described nationality?
Yes.
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 Exactly. And my submission
Which is our
not.
basic problem, I think.
Agreed. So, as far as Preddy is concerned, I've made the point myself that the question to whom is the criterion being applied is material. I point out, obviously, that the exact correspondence test is the test adopted by all members of the court, even though it was ultimately a majority decision. One sees at paragraph 74, page 1624, Lord Neuberger adopting what my lady said at paragraph 17 to 24, and one sees at paragraph 82 Lord Neuberger describing what was said there as the well, in the last sentence of the paragraph, the well-established requirements of direct discrimination as explained. And in the case of Lord Hughes, paragraph 87, 1626, unanimity as to the principle or the test, the exact correspondence test, but with respect disagreement as to the group to whom it was being applied. Now, on the basis of that authority, or those authorities, my submission is, as you appreciate, that Mr. Allen has to submit that Bressol and Pat Malnice should have been decided differently, and that the reasoning that underpinned those cases, as well as Preddy and Schnorbus, was wrong. Really, that's all I propose to say on those authorities. After that, we've got what I've described, I hope not too disparagingly, as Mr. Allen's supporting arguments. I do submit that ultimately the argument about the four cases that we've just looked at is the argument that's going to resolve the case. And what I've done is set out, I hope helpfully, a reminder of the parts of our case that deal with the arguments that he developed orally, with some additional points that I might have made orally, and unless you ask me to, I don't propose to. I take it up at the time of the court. I'll leave the note with you, but do let me know if you want me to develop any particular point.
Is there anything? It would appear not, Mr. Lindsay.
Thank you very much.
Okay. Thank you very much indeed. Ms. Hannah, do you follow?
Sorry, Sally, sorry, I'm so sorry. Do you want this? Yeah.
My lady, I'm grateful for the court's indulgence in terms of my very short submissions, which I'm grateful or hopeful that my lady's read.
Yes, we have.
There were two, and there were my initial submissions set out in the respondents' case, and there were supplemental submissions, which frankly now are hopefully superfluous to your ladyship's needs in terms of the PCP. But before I push on in terms of the indirect discrimination claim at all, can I just check that whether my lady needs any help in respect to the PCP case at all? Because the way my learned friend Mr. Allen left it was that he urged this court to help him construct a PCP, which left me a little bit lost as to how I could help.
Yes. Very fairly put, Mr. Rahman. As I understood Mr. Allen, what he was basically saying was, in this particular case, it is direct discrimination or nothing. But he didn't want the court to rule out that there might be cases involving similar factual scenarios in which one could construct a viable PCP, which would affect one group more disproportionately. But he's not suggesting it in this case.
I'm very grateful. Indeed.
That's how I understood it, because if he was asking us to devise a PCP, he was asking too much.
I'm very grateful.
That's not the job of this court to do that.
In terms of that.
Still less to do it without giving you an opportunity of answering it.
No, indeed. And perhaps I can assist in terms of that point. I think the task that this court is faced with is how do we infer or deal with the question of nationality, which is the only protected characteristic at issue, in a case where nationality isn't said to be the reason for the mistreatment. And the answer is yes. The only way I would submit that it can be done is in a case of indirect discrimination, not a million miles away from Pryddy. Short of that, it appears, looking at the way the current list of protected characteristics are devised, it can't. And I put it as bluntly as that. And certainly Bressel and Paramita suggest that there are other routes, but they don't help in this case. And I think Madam's absolutely right. I think on these facts, I can't see that they help. And I may be wrong, and I said both my learned friends are far more learned in law than I am, but it seems to me coming to this afresh, on these facts, neither of them quite sit happily, certainly with the task that my lady is faced with. And it's this. This is the task that my lady is faced with. In the composite set of factors, as it's put, is immigration status. No more, no less. It's in the mix. It's somewhere there. My learned friend, Mr. Allen, puts it this way. He says it's the tool. Well, it's not the tool. It's the passport is the tool. Well, no, it can't be, because it has to be the combination of all the factors. They all have to be there for these set of facts to arise as they apply to Miss Unu and Mrs. Taiwo. Without any of them, there is a question mark as to whether these facts would arise. And this case is very much about its facts. It isn't a general catch-all argument about vulnerable migrant domestic workers. It's about these two individuals. And I pause there for a minute. One of the difficulties I think every court that has looked at these facts has had, and I have had, trying to work my way through this, is the strained approach to defining both the group that Miss Onu and Miss Taiwo belong to, and the strained approach to the comparator. And I say that with some justification, looking at the different comparators the different courts have thrown up, and certainly the Court of Appeal, we gave up on the comparator altogether. And we were in the Shamoon school of, well, we don't really need the comparator, it's far too complicated an exercise. Let's just look at the reason why. And if one goes back to the way my learned friend, Mr. Allen, puts the migrant point, and my learned friend refers to Rogers, and if my lady recalls, that's in Bundle 3, tab 35. I don't propose to refer to it in any detail. Say this, the colourful examples given in Rogers, and they were there, and I was circumspect as to whether I would repeat them in front of this court, but they serve a purpose, and it's this. If you have a group of people who you cannot identify, you would use a blanket approach such as migrants. And all the cases that are pointed to in respect of this, even Orpheus, because it's primarily an indirect discrimination case, it's about a group where you can't identify the individuals, which is why you use the migrant blanket approach. If my lady will contrast that with the facts of this case, there is no doubt about the protected characteristic and the specific nationality in this case. So it is a construct too far, I say, in terms of defining yourself in these facts, in this case, as a migrant per se. It is nationality, and the only nationality in the room in these cases is the Nigerian nationality. And I'm sorry to put it that way, but it seems the common sense approach. What then follows, both in Unu and Mrs. Taiwo's cases, there's no suggestion that they are being treated less favourably because of their Nigerian status. It is, I apologise, my lady, I'll give my lady a chance to...
No, it's all right.
Grateful. It's a rather amorphous approach, saying, yes, we know everybody's nationality, but we're going to look at the immigration status and then infer that you belong to some other group. Well, strained again, I would suggest. Then there is the discussion about vulnerability and the immigration status creating the vulnerability, and the vulnerability being interwoven with and part of the immigration status. Well, accepting as I must that there will be occasions where immigration status in indirect discrimination cases will lead to claims on the basis of nationality, I struggle with this. How does a particular immigration status create vulnerability for all Nigerians as compared to another group? It doesn't. And again, it is a stretch too far, a leap too far. It gets much worse. We then have a scenario where we have the interplay of domestic workers, and that too is said to point towards nationality. I again struggle with this. Not all Nigerians are migrant workers. I struggle with the fourth point, which is worker per se. Not all Nigerians who come to the United Kingdom are workers in any sense of the word. What my learned friend Mr. Allen does by bringing together these four composite factors is taking himself very far indeed from nationality being the reason or a reason for the mistreatment in this case. And I put it that way, the reason or a reason, because that's his case, and I'll come to that momentarily. But if that wasn't enough, we then add into the mixture the poor socio-economic group. Again, how can I possibly see a causal connection between poor socio-economic group and nationality? And then a suggestion that both appellants are not as well educated as they might hope to be because of their circumstances. Now we are so far away that we cannot see nationality no matter how we try. I say the reason or a reason because of this. Again, Mr. Allen puts his case, I apologise, my learned friend, Mr. Allen, I do apologise, puts his case on this basis.
We'll assume he's learned, you don't.
As I said, I'm concerned that I don't address anybody properly. He doesn't say it's the only reason for the mistreatment. It's in the mix. And I think this is a concept discrimination lawyers are used to. If it's part of the reason, then it's discrimination. There is an element of discrimination in the reason, therefore it is discrimination. Well, that works if you have a protected characteristic, but if you're not at the protected characteristic to begin with, it's an approach that doesn't work, because what we do need where we don't have a clear connection between the various factors and nationality is a very clear finding that the only reason or the operating reason would be immigration status in this case. But on his own definition, it doesn't work. It gets perhaps more difficult to follow when asked about motivation. And I say this in these terms. The description that was given by my learned friend, Mr. Allen, isn't motivation. It is the reason for the treatment, the modus operandi for Miss Taiwo and Miss Onu's employers. And it was described as this: they wanted to be able to have a servant who they could completely control to serve them and their families, irrespective of free will of the individual, the labour code, which supported that. And there's no mention of nationality or immigration status in that. It's about control, pure and simple. The reason why they were treated the way they were was control, or the need for control, or the need to create control. And discussing, as I have been, the difficulties in this case with various other members of the bar, we came up with perhaps, and I won't give anybody named credit, but some possible alternative ways of creating control on these facts. One example was the exploitation of an addiction to drugs or alcohol or some other substance. That would also create control, and my lady will be aware of various cases in the press where that has been done by unscrupulous employers. It would create a very similar dependency on the employer and a vulnerability. Another example that was couched or raised was perhaps an employee claiming benefits unlawfully whilst working for an employer, and the employer becoming aware of that and exploiting the employee, for example, as in this case, to pay them below the national minimum wage or get them to work longer hours, and so on. These are all scenarios that create control. So control is not the unique product of this immigration state, of the sponsor-based immigration status that this case is pinged on at all. And indeed, one can see the beginnings of a comparator there. The decision that your ladyship will have to reach is, as a starting point, if my lady were to indulge in the comparator exercise to try and understand the reason why today on the case that's put before your ladyship today or not. And I would suggest in simple terms that everybody has got the comparator exercise a little confused, it would appear, up until and including the Court of Appeal. And my Lord Wilson asked my learned friend, can one shape the comparator or the comparator exercise to ensure a result? Well, the answer is perhaps yes, but perhaps no. And the reason why you can't is what's now Section 23(1) and 2 of the Equality Act, which sets up the factual scenario where you have to be broadly comparable, no material difference. And that is the safeguard to ensure that one doesn't construct a comparator to suit one's purpose. And if one does that in this case, throwing in the composite factors as we're asked to by my learned friend Mr. Allen, one comes up with a very strange scenario, and I put it in these terms. Having done this myself, I came up with this possible comparator, not the comparator clearly that my lady may or may not want to apply. I have to say I don't necessarily accept it's a British national, but that's a concession already been given by the respondents. But assuming it's a British national, that's a comparator. He or she may not have to be a domestic worker. He or she may not have to be male or female. There may be a preference for somebody who speaks Yoruba but that's not necessarily a migrant. There are plenty of Nigerians in this country who speak Yoruba. Belonging to a socio-economic background that's perhaps not, leaves one open to being told things that aren't correct. That's also not the sole preserve of a migrant. Educational difficulties, not having the best education in the world, also leaving one open to being told that things aren't quite the way they are. That's also not the sole preserve of a migrant. Poverty, that's a relative term, clearly. But there are people that are perhaps not doing as well as they might in this country and who might be exploited along very similar lines if we were to do that. Applying both of those, that comparator to both cases, I think on my very simple analysis, certainly in Taiwo, it would appear that with the Yoruba requirement confirmed, there's no less favourable treatment. So one doesn't have to even go on to look at the protected characteristic. In ONU, there's a very simple impediment, and your ladyship might recall it. It's the finding of the tribunal that a British national wouldn't be treated the same way by one of the respondents. And your ladyship might also recall the AT, that was dealt with this way, that reply couldn't be relied on because, and I'll put it in these terms, it appears that the question of how you would treat a hypothetical comparator was put to the respondents without telling them what facets that hypothetical comparator would have. It was put bluntly this way: would you treat a British national that way? Well, that's improper for a start in a discrimination case, and certainly one where you're trying to put a hypothetical comparator to a respondent witness in that way. That's a matter for the tribunal and those that would adjudicate on the evidence in the round. So I think that's right. One could exclude that proviso. So one ends up with the same answer, which is neither of them would be treated differently than the claimants in this case if one created the right comparator. It is, perhaps it's my ineptitude or my inexperience, but it strikes me that nobody undertook the task or addressed their minds to the task and looked for a simpler solution to a problem that seemed too difficult for them. But, my lady, unless I can help specifically more, that seems to be my answer to this question. In other words, certainly immigration status can be a factor in an indirect discrimination case, not in a direct case. The other authorities that are applicable or relied on, although helpful in terms of approach, and I say helpful in terms of this approach, they're the only reason that can apply in a case where one is relying on another factor pointing towards a protected characteristic is it must be the only reason, which comes out of PREDI and the other authority. So that, to that extent, they're helpful, but perhaps not further. But on my analysis, it would appear that this treatment really does have nothing to do with nationality whatsoever, despite my little friend Mr. Allen's very inviting and enticing submissions, and I think laudable submissions, as to try and protect what is quite obviously a group that is vulnerable. However, it doesn't quite apply to the facts in this case, and it is a stretch or a leap too far on the facts of both these cases, unless I can help specifically any further.
No, thank you very much indeed, Mr. Rahman. Right. It may be that simple solutions are the best solutions.
I'm a simple soul.
I say not. Nobody has yet made up their minds in this case. Mr. Maldi. Mrs. Ray.
Can I just apologise for putting a box on the bench? That's my rack behind, I'm afraid.
Well, would you like the one that's over there?
I should be fine with that. It's just to keep the volumes safe. That's...
Oh, yes, you help me.
My lady, in the case that we advanced in writing, we said that we saw in paragraph 22 that this case, page 66, that the case depended on the fact that a person's particular migrant status in the UK is a direct function of their nationality. So if they're abused because of their vulnerability arising from that status, their treatment is on racial grounds. And we come back to that proposition. If we're wrong and you hold that immigration status is not to be seen as a part of, a function of, whatever word you use, nationality, we're wrong. The submissions that have been made yesterday from Mr. Linden suggested to you that you should construe nationality strictly. And I wanted to just think through for a moment what that meant. I will in a second suggest that it's not apt to simply say that it has to be construed strictly, it has to be construed in context. But take it for a moment at its height, what Mr. Linden was submitting. It would mean that the prohibition on race discrimination, where race is meaning nationality, is limited to the class of case in which there is a distinction drawn because somebody is British or not British, or because somebody is French or Irish or American or whatever it is. It's simply to those classes of case where nationality in the simplest and clearest term is enunciated. Now, we know for a fact that the word nationality was introduced into the legislation following the London Borough of Ealing. And we've put in the white paper, paragraph 56, which shows the background to the reasoning that led to the Race Relations Act of 75 being amended. It's specifically saying, and dealing specifically with the problem that was in Ealing, the London Borough of Ealing case, that nationality includes citizenship. So we've got a step beyond nationality itself in the way in which the phrase is enacted, because citizenship is a function of nationality. And citizenship can come in a series of different ways. And anybody who's done immigration law for even superficially for a long period of time will know that there have been different kinds of British citizenship, overseas British citizenship and so on, were constructs of nationality at different times. It's even possible to have a circumstance in when possibly your nationality can be withdrawn. So I would submit that the premise for the argument that Mr. Linden adduced eloquently yesterday is simply wrong. Nationality isn't to be construed as simply meaning only those classes of cases where the actor whose acts are impugned has relied on someone being British or not British, French or not French, etc. It is intended to be put into a broader context. I would submit that that is obvious from the history of the provision. It is obvious from the fact that nationality is a subset of race within the legislation itself. It informs the concept of race together with colour, ethnic origin, and so on, which suggests that the legislator saw race in a comprehensive sense as covering a series of aspects that might be thought to be within the word race as it's commonly used and understood. We would submit also that those cases in the criminal context, which we've referred in our printed case, also support the approach that we took. If you abuse somebody in some way connected with your nationality by calling them a bloody foreigner, you're within the scope of the Crime and Disorder Act using exactly the same definition. That conclusion, we say, was right, and it follows on from an understanding of the policy of this area of legislation. What's right for the Crime and Disorder Act is certainly right in this context. And indeed, on some of the facts before the Employment Tribunal in both Onu and Taiwo, there might well have been a prosecution under the Crime and Disorder Act that might well have been successful because of the way in which aspects of the situation connected with race in this nationality context were used against these individuals. So that's our first reply proposition. Take Mr. Linden's case at its highest, and you undermine the scope of this legislation. And you undermine it in quite a dangerous way. One could see immediately that if his case was taken at its highest, defences would be put forward in criminal cases when the Crime and Disorder Act was advanced, which would quite seriously undermine the evident policy of that part of the legislation. And I think it's a short and simple point, but it's highly important that a coherence between the criminal and the civil law on that area is maintained. So that's our first point. Secondly, he said, made a specific point about this, which I have to correct. The specific point was to say that the question of caste had been raised as to whether or not that was encompassed within the scope of race discrimination, and it had been ruled that it was not. If you recall, he referred to a case called Chandok and Turkey, which is cited in the printed case. Regrettably, for reasons which I'm not sure, it's not actually in the bundle of authorities. We will hand it up in a moment. But the point about Chandok and Turkey, in which my friend Mr. Milsom was counsel for the employee, and the context of it can be put quite shortly. Perhaps it's helpful to just hand it up, because I make this point very quickly by reference to it. While that's happening, I can say that there was an argument as to whether or not there was a political argument as to whether there should be protection from caste, discrimination on grounds of caste. And there was a legislative direction that the minister should inquire into this and should amend the Equality Act if it was thought appropriate and necessary. If the court will kindly turn to page 534 in the law report of Chandok and Turkey. And if you'll go to paragraph 24, you'll see there's a citation from the Enterprise and Regulatory Reform Act of 2013 at letter G. So the Minister of the Crown must, by order, amend this section so as to provide for caste to be an aspect of race. And that was to follow on after an inquiry into when that was necessary or not. The Employment Relations, the Equality Act was amended accordingly in section 9.5, but there was never an order bringing that section into effect. And the reason that the order has not been made to bring it into effect was that the judgment of Mr. Justice Langstaff in Chandok and Turkey was given, as it were, after the enactment, but before the minister thought it was necessary to do so. The facts of Chandok and Turkey was that an amendment was made to particulars of claim suggesting that the caste basis of the plaintiff, the claimant, meant that she had suffered ethnic discrimination on grounds of ethnic origin. There was a strikeout application to try and get that removed, saying that it couldn't be so. Mr. Justice Langstaff, in the Employment Appeal Tribunal, held that the concept of discrimination on grounds of ethnic origin was capable of encompassing the kind of allegation of caste discrimination that was made by Ms. Turkey, because the essence of it was that she said that she'd been discriminated on grounds of descent. Now, what do we get from all of this? 2 points. First of all, absolutely contrary to what Mr. Linden said, provided your pleaded facts in a case in which you say you've been discriminated on grounds of caste amount to a claim of discrimination on grounds of ethnic origin, you can make your case. That's all. So that's point one. Point two is it shows the flexibility of the concepts within race discrimination to encompass different kinds of fact situation. And that's the important point for our submission about how you should approach nationality. I'll leave the case with you, but you may want to just notice, to make good what I've just said, the holding on the first page, dismissing the appeal. That's the appeal by the employer to try and get this matter struck out. The interpretation of Section 9.1 of the Equality Act was a matter for the courts, and any view of its meaning Parliament might be taken to express when subsequently legislating couldn't be conclusive, that, since ethnic origins in paragraph C of Section 9.1 had been held to be a wide and flexible phrase covering questions of descent, at least some of those situations which would fall within an acceptable definition of caste would fall within it. So the passage that you get out of it from the head note is that ethnicity is to be construed on a wide and flexible basis, but obviously consistent with the purposes of the legislation. And you can see from the cases referred to that our two friends, JFS and Mandla and Dali in particular, were referred to. You'll see that on the following page. No surprises there. So our submission is that, quite contrary to what Mr. Linton was saying yesterday, nationality has to be understood as part of the concept of race. Its origins have to be understood. Its application into specific fact situations requires analysis, but it's not to be applied simply on the basis of are you British, are you French, etc. It's got to be looked at in greater detail. That's our first point in reply. We accept that if you reach a conclusion that immigration status is too far removed from nationality, interpreted on the basis that I've said, we lose on this basis because we can't make the link. The finding here is discrimination on grounds of immigration status. That is the finding. If, on the other hand, you're with us and you say it's not too far removed from the concept of nationality, then we would say that this is inherent discrimination, and you don't need to spend an awful lot of time constructing hypothetical comparators. But I do want to say just a short word about comparators because of the way the submissions have been developed in relation to Pat Malnice and so on. What happened, you will recall, is that in the ONU case, there was a specific submission about the kind of treatment that a British person would have received from the Akwiwus. And that finding was essentially part of the way it was reasoned out at the end. So the comparator was put forward as being a British person who might be treated, it was thought, would be treated better. Now, it's old law in the field of equality law that you can have two kinds of comparators. You can have perfect comparators and you can have evidential comparators. Criterion cases typically give rise to perfect comparators. Where you've got a Pat Malnice type rule or a Bressol rule, you're either in or you're out. And you can look directly at the people who are out as perfect comparators. But where you haven't got a criterion case, you've got a series of bits of treatment. You won't find ordinarily somebody who is, as it were, a perfect comparator who actually exists. All this was discussed in Shamoon. If you remember, Shamoon was the case in Northern Ireland where I think it was the superintendent of police was complaining about the fact that she was not given continued equivalent responsibility, I recall, in relation to traffic or motor traffic. There was no perfect comparator, but it was pointed out that other superintendents in other part of the Northern Ireland Police Force might help evidence what was the true reason for the treatment that had been received. We think the right approach to the way in which the ONU Tribunal looked at the way a British person might have been treated is really essentially as evidential. The debate in this court has made us focus down, because of the reference to Pat Malnice, to exactly what the comparison is. And that's why I answered the question yesterday with the permission of the court in answer to Lord Wilson's question. He's repeated it again today. Here, you can divide between those people who have the specific position of these two appellants and those otherwise lawfully in this country, but who are not subject to the same immigration control. And they couldn't, it's obvious, as soon as you pose it in that way, it's obvious that class of person could not and would not have been controlled by these respondents in the way that the two appellants were. What happened in ONU was that, as it were, honing of the comparison didn't take place. The general evidential submission is made, a British person wouldn't have been treated like this. That's obviously right. Such a British person would fall within the category of people lawfully here, not subject to control in this way. So that's all I think one needs to say about the points that have been made as they touch on the case that we've advanced. I want to say very shortly that there are aspects of the submission on Bressol, Pat Malnice, Hall and Preddy, with which I do make some disagreement. Firstly, we've made it absolutely clear in our case that we accept Pat Malnice is right. It wouldn't be our position, ordinarily anyway, without having made a specific submission to this court to ask you to reconsider Pat Malnice. We don't make that. We haven't said that the House should revisit, the Supreme Court should revisit a previous recent decision of this kind. Quite happy to take Pat Malnice as it is explained by Lord Hope, and I think as understood by my lady and Lord Walker in the passages that we referred to yesterday. It's a composite case in which the right approach was to take both the discriminatory and indirectly discriminatory parts of the rule, put them together and say we've got to follow the Bressol line. And that's as far as we go. We think that Lord Justice Underhill got involved with the Pat Malnice line of authority because of the reliance on the treatment of a British worker in the ONU judgment. The fact that in the argument in the ONU judgment, the argument that was put forward by my friend Mr. Rowbottom was to say, look at what would have happened to a British worker. They wouldn't have been treated in this way. And that led him down a path of inquiry, thinking that the division was simply into British workers and those with domestic workers' visas. And that led him into the question about whether there was exact correspondence and indissociability and so on. But if you analyse it in the way that we have done, and I've done it now, then the relevance of Pat Malnice seems to fall away. And that's why in our case, we've said Pat Malnice needs to be understood as one of those cases where there's a single criterion, where it divides the population which is readily identified into those that comply and those that don't. That's its precise factor, its precise aim, that class of case, such as Pat Malnice and Bressol and James and Eastley. Now, I think that's the majority of the points that I wanted to make, but would you allow me just to look at my notes?
Just have a look, yes, just check.
passage. There are two short points. To some extent, I've touched on both of them, but I think in fairness to my juniors, I need to make the points to you. Firstly, Mr. Rowbottom makes the point that in the reply submission from, I beg your pardon, the written submission handed up this afternoon by Mr. Linden, paragraph 6, that it's simply wrong when it said the tribunal in the present case is the equivalent of the jury. It had to decide whether the conduct of the respondents demonstrated that they were significantly influenced by nationality. Mr. Linden goes on, the tribunal found as a fact that they were not. They were merely influenced by A's vulnerable immigration status, which is not the same thing. Now, if he's right, an immigration status is not a part of nationality, that sentence is right. If we're right, it's wrong. That's repeating really what I've said already.
Well, that often happens. If what the respondent says is right, you're wrong, and if what you say is right, they're wrong.
I know that I've got to face my juniors when I leave court in a moment. So, but I think that that's important. The other point that I hoped I'd made, but if I haven't, I want to make sure that I have, is that it's quite a commonplace in the area of discrimination law that the treatment itself is that the treatment itself actually imports an aspect of a protected characteristic. Sometimes it's not obvious that it does, and you've got to work it out, but sometimes it does. The cases we've debated are obviously James and Eastleigh Borough Council, where we quite quickly worked it out. But there are many cases in which this point has been made. We simply say that the treatment here, to the extent, as identified by the two tribunals, that it was based on the control that came from the domestic workers visa, was inherently part of the protected characteristic. Many cases that exemplify that from James and Eastleigh Borough Council, the Birmingham City Council case, Nagarajan, JFS, and so on. So I just make that point as well too. But otherwise, I think that covers the ground. Oh, I'm getting another note.
You're getting another note.
Oh, quite rightly so. Yes, Lord Toulson asked yesterday whether there was a possibility of an action for statutory tort for breach of the Modern Slavery Act. And the short answer is no, there isn't. The slightly longer answer is that it was, during the course of the passage of the bill, suggested that it might be a good idea if that was expressly said. Amongst those that work in this field, it's readily accepted that there could be cases in which torts of intimidation, false imprisonment, assault, variations on trespass could be brought forward. The biggest problem in relation to those is accessibility to the court after the changes to the legal aid structure. So there are issues around that. My lady yesterday raised the question about, in a sense, anticipating what I hadn't said, but what I hope perhaps I'd implied in the fact of this litigation. There is a strong convenience argument on being able to bring these cases in the employment tribunal.
Yes, we appreciate that.
That's not a reason for us to succeed, but it is definitely a reason why we want to know if we're successful or unsuccessful, as you might expect. I don't think I need to develop that to you.
Thank you very much,
Thank you.
Mr. Allen. And thank you to everyone in this. Puzzling is the right word for it, is it not? It's a puzzling case, and we will go and puzzle it out as best we can. But thank you all for your assistance, particularly those who came into the case recently, and those who were initially prepared to do so pro bono. We're most grateful to you all. And as we said, we'll go and puzzle it out.